If an introduction is meant to inform an otherwise ignorant audience about a speaker, then clearly introducing Professor Sen to an audience like this is a wholly nugatory task. Equally, if an introduction, on the other hand, is simply an exercise in flattery, then why should today's lecturer bother about our praises when the whole world has given him several standing ovations? I simply want to say how honored we all are to welcome Amartya Sen to Oxford today, a university which he graced with his presence regularly for some time. I think the size of today's audience, the largest number of people I've ever seen in this great Christopher Wren building, underlines the main point that I want to make, which is that no public intellectual in our times has better bridged the worlds of ideas and practical policy making. Professor Sen has been engaged with all the main economic and political issues of our times: welfare, famine, global poverty, the condition of women, the universality of values, and the relationship between the correction of injustice and political accountability. Clearly, recent economic events internationally have not dented Professor Sen's argument that markets are not self-regulating. The growing divisions between rich and poor in the world have shown the imperative of generous and assertive interventions in Africa and Asia in particular. Climate change, too, requires political action to prevent greater injustices still being heaped on those who are already disadvantaged, as well as representing an existential threat to all of us wherever we live. Professor Sen has brought together many of his arguments in this book, The Idea of Justice, which was published this summer. If even half of you who've squeezed in here today purchase the book after this evening's lecture, then it will rocket to the head of the bestsellers list, replacing several books by footballers' wives. Professor Sen. Thank you.
Well, I'm really delighted to be back at Oxford and back in very familiar settings. I've spent 10 years teaching here, 10 very happy years. And as the Chancellor kindly mentioned, I very often come back. There's a reason for that. And I'm really delighted that I get another opportunity now, and I would like to thank the Chancellor also for his very kind introductory remarks. I think, as has been announced, the subject of the talk is the pursuit of justice. And I begin with referring to something slightly different. The subject of this lecture is justice, particularly the relation between theories of justice and the guidance that we get from them for our practice. But I cannot begin discussing what I want to say in this lecture without first talking about my friend Jerry Cohen, G.A. Cohen, titular professor of social and political theory here at Oxford, who died suddenly last August, plunging his friends and the world of philosophy in gloom. John Dryden wrote in 1698 in Epistle to Peter Anthony Motu, I quote, "Words once my stock are wanting to commend so great a poet and so good a friend," unquote. It is indeed very hard to talk about a close friend. I was immensely privileged to have so fine a philosopher and so marvelous a human being as a close friend over more than a third of a century. We first met in 1972. I had gone to see Jerry at University College in London, where he was then teaching, and we talked about many things, but quite a bit about Marx, particularly the type of reasoning that Marx found convincing, on which I had some questions, and Jerry had some answers. I remember being struck by the remarkable combination, almost more than anything else, of combination of conviction and playfulness in Jerry's exposition of Marx. I should mention here that today's meeting, this lecture, was originally organized by Jerry Cohen. Since he wanted to give me a platform to speak about my new book, but while he was kind, he was certainly kind to the book as the book jacket brings out, but I want to emphasize that Jerry wanted me to have the opportunity of presenting my arguments here, despite the fact that the lines of reasoning I criticized included his own, and despite his not being convinced by some of the arguments I present in the book. He told me that we were going to argue about this today in this meeting, which we are not able to do, but I would not like you to think that he agreed with what I'm saying. And that I absolutely owe to him to make clear. Jerry was actually a wonderful critic, as well as an original thinker of remarkable reach. And in Jerry's death, we have lost a giant of the profession and a great Oxford intellectual who combined an enviable sharpness of reasoning with an unshakable sympathy for the underdogs of society. I turn now to the subject matter of this talk, the theory and practice of justice. Let me ask a technical question. Am I audible? This afternoon I was being told that I wasn't doing something like getting sufficiently close to microphone. But I'm all right, am I? Okay, good. If I'm not, then raise your hands or something of that kind. Now, consider the much repeated expression that something could be right in theory, but wrong in practice. That bit of simple wisdom has a strangely attractive appeal. I say strangely because the reasoning behind that accommodative discernment, despite its nicely lenient liberalism, is fairly hard to elicit. If a theory is wrong in practice, how could it be right in theory if the theory is about what to practice? So to be right in theory, despite that, a doctrine must be not about practice at all. But then, if the doctrine is not about practice at all, how could it be possibly wrong in practice? Something or other must give somewhere to make room for that tolerant reconciliation of right with wrong. Much more can, of course, be said in defense of that accommodative wisdom, and going beyond the quick counter-argument that I've just outlined, almost vulgar quick counter-argument, with deeper investigation of the relation between theory and practice, possibly invoking Kant and Burke and Mill. That is not, however, the direction in which I want to go right now. But the contrast I want to start from is much simpler than the profundity of the general relation between theory and practice. The contrast concerns the question that the theory of justice takes as its subject matter, and the answers that could be of central interest to practical reason, to use the old-fashioned description, practical reason, of moral and political philosophy. The search for an appropriate theory of justice is not hard to argue has to be informed by what we actually want from a theory of justice. John Rawls, the leading contemporary theorist of justice, without a doubt, has argued that the search for objectivity in political philosophy has to be for, I quote from Rawls, a public framework of thought, unquote, that provides, I quote again, an account of agreement in judgment among reasonable agents, unquote. In my book, I have tried to discuss the force of this Rawlsian diagnosis and also why I find it to be such a good starting point for analyzing justice. Here I shall not go further into this question and simply accept the importance of agreement through reasoning as the basis of a theory of justice. This diagnosis does, however, lead to two further questions. The first issue concerns the subject matter of public reasoning about justice. What are the questions to be answered? What is to be resolved by a theory of justice? The second issue concerns the voices that should count in public reasoning, the voices that should be paid attention to in determining how to proceed in the practice of justice. From where should we look for reasonable agents? Should they all come from inside a given society or a country? Or can they sensibly come from far as well as near? Well, I began with Rawlsian foundations on the importance of reasoning and of reasoned agreement. My differences with Rawls, and indeed with many other mainstream theories of justice today, in fact most of them, emerge in addressing these specific issues. Before I go into the distinctions involved, let me mention quickly, to prevent a misunderstanding, that the idea that justice is to a great extent a matter of reasoning and of reasoned agreement is not confined to Rawlsian theory, nor only to contemporary political philosophy traditions, nor only to what are sometimes called Western traditions of thought. Over hundreds of years, literatures on justice in different parts of the world have attempted to make adequate room for reasoning in the analysis of justice, even though in some simpler anthropological classification, we are told a somewhat more befuddling story that reasoning is quintessentially of a Western kind in which the Eastern societies have not really participated. Again, I've discussed that issue in other books, including in my last book, Identity and Violence. However, even though there is nothing exclusively Western in the idea of relying on reasoning, there can be little doubt that the discipline of reasoning about political philosophy in general, and justice in particular, received an especially strong boost during the European Enlightenment in the 18th and 19th centuries, encouraged by the political climate of change and also by the social and economic transformation taking place then in Europe and in America. The leaders of thought in the Enlightenment did not, however, speak in one voice. In fact, there's substantial dichotomy, which has not received sufficient attention, between two different lines of reasoning about justice that can be seen among two groups of leading philosophers associated with the radical thought of the Enlightenment period. Isaiah Berlin, whom I also remember whenever I come here, since he was also a close friend, was more than anyone else emphasized how complex it is to interpret what Enlightenment thoughts were. One approach concentrated on identifying perfectly just social arrangements and took the characterization of just institutions to be principal and often the only identified task of a theory of justice. This way of seeing justice is woven in different ways around the idea of a hypothetical social contract, mostly there are, a hypothetical contract that the population of a sovereign state are supposed to be party to, the members are, as if they have arrived at that contract. Major contributions were made in this line of thinking by Thomas Hobbes in the 17th century and later by John Locke, Jean-Jacques Rousseau, and Immanuel Kant, among many others. The principal theories of justice in contemporary political philosophy, including preeminently John Rawls's theory of justice as fairness, draw in one way or another on the social contract approach and concentrate on the search for ideal social institutions. This approach to the pursuit of justice has three distinct features. First, it concentrates its attention on what could be accepted as perfect justice, rather than on relative comparisons of justice and injustice, and on the ways and means of removing recognized cases of big injustices in the world. Second, in searching for perfection, this approach concentrates primarily in getting the institutions and the arrangement right. It's not directly focused on the actual societies that would ultimately emerge. The nature of the society that would result from any given set of institutions must, of course, depend also on non-institutional features, such as actual behavior of people and their values and how they discuss things and their social interactions. In the book, I call this combination of the search for perfection and the concentration on institutions by the name transcendental institutionalism, which is, I fear, a bit of a mouthful. I concede that. Couldn't find a better word, despite having the best editor in the world, whom I see sitting here and helping me. It was difficult to find a simpler term that will capture the complexity of it. Since it sees the pursuit of justice, and the term is suitable, as a search for a perfectly just institution that could not be transcended on grounds of justice. The third feature relates not to the subject matter of reasoning about justice, but to the voices that should count in this reasoning. In the social contract tradition, the views that must receive attention have to come from those who can be seen as parties to the social contract. Given the country-by-country and nation-by-station structure of social contract, powerfully identified by Thomas Hobbes and pursued in mainstream political philosophy from then onwards to today, the contractarian tradition tends to confine the discussion to members of a given polity, in particular the citizens of each country who engage in deciding on the ideal institutions and corresponding values for that particular sovereign state. The need for impartiality in the treatment of different citizens within the country are accepted and celebrated, but there is no secure place in this formulation of deliberations of justice to go beyond the citizens of a particular state. There is no foundational demand for it. It may, of course, be that there are very good arguments, and Rawls himself has excellent argument when he talks about reflective equilibrium as to how individually we ought to go in that direction. But when it comes to justice and fairness, there's no demand on that as far as justice itself is concerned. If this type of impartiality can be called closed impartiality, as I do call it in my book, where impartial consideration is confined to the citizens only, we can contrast this with Adam Smith's insistence in the theory of moral sentiments, but also in the Wealth of Nations and in the lectures of jurisprudence, on the necessity to pay attention to the views of people from very far as well as very near. And this can be called open impartiality. I might take I don't want to do a commercial, but I do want to mention that this being the 250th anniversary of the theory of moral sentiments' first publication in 1759, there is an anniversary edition in which I was privileged to write a long introduction discussing Smith's ideas and how his different books relate to each other, and where, among other things, go into this question. The contrast with the social contract tradition, however, is not confined only to Adam Smith, not only to the distinction between what I'm calling open and closed impartiality. Indeed, a number of Enlightenment theorists, including, in addition to Adam Smith, the Marquis de Condorcet, Mary Wollstonecraft, Karl Marx, John Stuart Mill, among others. I was reprimanded by my friend John Broome earlier in a seminar today for mentioning Mary Wollstonecraft, but not her husband, namely William Godwin, and I do so now. I could have included him in the list. And they all took a variety of approaches that can be contrasted with the contractarian foundation advanced by Thomas Hobbes and others. That could be contrasted with that. These theories are widely different from each other, but they share a common interest in making comparisons between different ways in which people's lives may go, jointly influenced by the working of institutions, people's values and actual behavior, their social interactions, and other factors that significantly impact on what actually happens in the world, how our lives go, and what freedoms and capabilities we actually enjoy. As was mentioned earlier, it's the first of these two traditions, that of a transcendental search for ideal institutions through some version or other of the social contract, on which today's mainstream political philosophy largely draws in its exploration of the theory of justice. Indeed, Rawls's principles of justice, in his book A Theory of Justice, are defined entirely for perfectly just institutions. The principles are concerned only with them, though he also investigates, very illuminating, as I mentioned earlier, the norms of right behavior in political and moral context. Also, a number of other preeminent contemporary theorists of justice today have, broadly speaking, taken the transcendental institutional route. Many different ways they have done that. I think here of Ronald Dworkin, David Gauthier, Robert Nozick, among others. Their theories are totally different from each other, but share the characteristic of transcendental institutionalism. The social contract tradition also makes the analysis of justice inescapably confined to the limits of a sovereign state. I shall have to consider in turn the three features, in particular the focus on perfect justice, as opposed to comparisons and removal of injustice, the concentration primarily on institutions, and the use of closed rather than open impartiality in the Adam Smithian sense. I begin with the confinement of arguments about justice primarily to identifying perfectly just institutions. In understanding the contrast between an arrangement-focused and a realization-focused view of justice, it's useful to invoke an old distinction, very old indeed, from the Sanskrit literature on ethics and jurisprudence. They're reflected by two different Sanskrit words, niti and nyaya, both of which stand for justice in classical Sanskrit. Classical Sanskrit has 25 different words for justice, but these two are the preeminent ones. Among the principal users of the term niti are organizational propriety and behavioral correctness. This is what I discuss it in the book more extensively. Krishna does in Bhagavad Gita, or that part of Mahabharata, when he's asking Arjuna to fight and pointing out that that is the right way for him to behave. It has some feature that has Kantian comparisons, that it's your duty, you ought to do it. It's you're required to do it no matter what happens. In contrast with niti, the term nyaya stands for a comprehensive concept of realized justice. And that, in a sense, is Arjuna's position, who is saying, why should I fight this war? It's a just war. It's my duty, maybe, but I'll end up killing a lot of people. There will be huge carnage. Is this the right thing for me to do? So that's is a question. That's not a contrast I'm going to discuss today, though if it comes up in discussion time, with the Chancellor's permission, I'll be happy to go into that. In that line of vision, the role, that is in the Nyaya right of vision, the role of institutions, rules and organization, important as they are, have to be assessed ultimately in the broader and more inclusive perspective of Nyaya, which is inescapably linked with the world that actually emerges, not just with the institution or rules we happen to have, or ask the question whether the institutions or rules are right. The question is to judge them in terms of what's happening, including, of course, whether the institutions themselves are right. That comes to occupy a part of the broad Nyaya perspective, but not all of it. To consider a particular application, early Indian legal theorists talk disparagingly about what they call Matsya Nyaya, justice in the world of fish. Matsya in Sanskrit is fish, Nyaya is Nyaya in that sense, justice. So justice in the world of fish. And they had determined, on the basis of whatever biology they took recourse to, that this is the world where a big fish can freely devour a small fish. And the small fish has no recourse to any kind of appeal against it. We are warned that avoiding Matsya Nyaya must be an essential part of justice in the world. And it's crucial to make sure that the justice of fish is not allowed to invade the world of human beings. It comes up again and again. The last reference I saw is in 8th century, when one of the Palo kings of just conquering a part of Bengal, saying this had been Matsya Nyaya, now it's going to be different. So it had a huge, over 1,500 years, huge sway. The central recognition here is that the realization of justice in the sense of Nyaya is not just a matter of judging institutions and rules, but of judging the societies themselves. No matter how proper the established organization might be, if a big fish nevertheless could still devour a small fish at will, then that must be a patent violation of human justice as Nyaya. Let me consider an example to make the distinction between Niti and Nyaya clearer. Ferdinand I, the Holy Roman Emperor, famously claimed in the 16th century, I can't pronounce Latin properly, I wish this was Sanskrit translated, but anyway, fiat justitia et pariat mundus, unquote. I must say I lack nerve and never managed to say the grace in Sanskrit in Trinity. It just shows a complete lack of character, I think. And this can be translated as let justice be done, though the world perish. The severe maxim could figure as a niti, a very severe and very austere niti, that is advocated by some. Indeed, Emperor Ferdinand just did just that. But it would be hard to accommodate a total catastrophe, the world perish, as an example of a just world. When we understand justice in the broader form of Nyaya, if indeed the world does perish, there would be nothing much to celebrate in the accomplishment, even though the stern and severe niti leading to this extreme result could conceivably be defended with very sophisticated arguments of different kinds. A realization-focused perspective also makes it easier to understand the importance of the prevention of manifest injustice in the world rather than seeking the perfectly just. As the example of Matsya Nyaya makes clear, the subject of justice is not merely about trying to achieve or dreaming about achieving some perfectly just or society or social arrangement. Even if you don't have Matsya Nyaya, you could have injustices of many different kinds. I might have mentioned just in passing that, for example, among the opponents of Matsya Nyaya, where a small fish could be arbitrarily eaten by a big fish, are many who have a very stratified, where the upper castes have a higher role than the lower caste. That's compatible with there not being a Matsya Nyaya, because still you can't be arbitrarily consumed by somebody else. There is some rule of law, as people say. And I think, so it won't be perfectly good, perfectly just world, but what is being suggested is that it would be an elimination of a severe injustice, and like avoiding the dreadfully unfree lives of the underdogs in a state of Matsya Nyaya. For example, when people agitated for the abolition of slavery in the 18th and 19th centuries, They were not laboring under any illusion that the abolition of slavery would make the world perfectly just. It was their claim, rather, that a society with slavery was totally unjust. Among the authors mentioned earlier, Adam Smith, Condorcet, Mary Wollstonecraft were quite involved in presenting this perspective. It was the diagnosis of an intolerable injustice in slavery that made abolition an overwhelming priority, and this did not require the search for a consensus on what a perfectly just society would look like. Those who think reasonably enough that the American Civil War, which led to the abolition of slavery, was a huge strike for justice in America, would have to be reconciled to the fact that nothing adequately distinctive can be said about the enhancement of justice through the abolition of slavery if we use the perspective of social contract theory, when the only distinction is between the perfectly just and the rest. And let's see why that is the case. Sure, there would be no room for slavery in a perfectly just society, if we can identify such a society. But there would not be any room for a million other violations, big and small. In a framework of comparative justice that concentrates on enhancing the freedoms and capabilities of people, the abolition of slavery need not wait for a comprehensive transformation involving the removal altogether of all the large multitude of transgressions. The same applies to the manifest injustices today that unnecessarily limit human lives and capabilities. Thanks to this plurality of surviving principle, and the plurality could be part of the justice on which there is agreement, but the plural principle, in some cases we agree, in other cases not, we may not be able to resolve on grounds of justice alone all the questions that may be asked. For example, whether a 40% top tax rate is more just than or less just than a 35% top tax rate. And yet we have every reason to try to see whether we can get reasoned agreement on removing what can be identified as clear injustice in the world, such as slavery, or the subjugation of women, or extreme exploitation of vulnerable labor, which so engaged Adam Smith, Marquis de Condorcet, Mary Wollstonecraft, and later John Stuart Mill and Karl Marx. Or today, the gross medical neglect of the bulk of the world population through the absence of medical facilities in parts of Africa or Asia, or a lack of universal health coverage in most countries in the world, including, oddly enough, the United States of America. Or the prevalence of torture, which continues to be used with remarkable frequency in the contemporary world, sometimes practiced by the pillars of the global establishment, or the quiet tolerance of chronic hunger, for example, in India, despite the successful abolition of famines. And it's actually much more generic than that. Just day before yesterday, I was looking at the latest U.S. Agricultural Commission report, which indicates that about 40 million people have hunger in the United States, which is amazing, seeing the prosperity of the country. In this alternative approach, we don't begin by asking, what would a perfectly just society look like? Even though that question may sometimes have an illustrative role in helping to clarify our mind. I want to emphasize, I'm not denying that algorithmic value of going through that reasoning. The question is that you still have to keep your eye on the ultimate prize, which is to identify injustices that we ought to give priority to removing. We begin instead by asking what remediable injustice could be identified on the removal of which there could be a reasoned agreement today. One of the limitations of the social contract approach to justice is the unjustified conviction that there could be only one precise combination of acceptable principles. And despite its implausibility, that, at least to me, that assumption is needed for the social contract approach to justice, which takes its job as identifying uniquely a combination of ideal social institutions. In contrast with this rigid insistence on most contemporary theories of justice, the alternative, the social choice approach, allows the possibility of a plurality of competing principles, each of which is given a status after subjecting them, and that's very important, all to critical examination and scrutiny. It is, of course, important to scrutinize critically every principle that is proposed, and some may well get rejected after a searching probe. But the claim here is that more than one competing principle or set of principles may actually survive on the basis of their reasoned justification. In my book, I discussed a case in which 3 children are competing for a flute, and they give arguments in very different lines. Anne demands the flute on the ground that she alone can play the flute. The others have no clue how to play it properly, which they don't deny. Bob argues for getting it on the ground that he had no other toys to play with, while others are well supplied with amenities, which again others don't deny. And Carla claims it on the ground that she had actually made the flute with her own labor. The others confirm this. None of the claims are immediately dismissible, and a just arbitration has to weigh the claims of all these competing grounds. With the Rawlsian original position, there will have to be one of them would get priority, or one balance of them. In any particular case, we may, of course, eventually decide what would be the right thing to do. But even reasonable people can come to very different conclusions in any specific case. No mechanical priority applicable in all cases in placing one of the 3 grounds over the others may be convincing to all, with reason. Indeed, sometimes even at the end, an element of arbitrariness may be left in the decision process in a particular case. The fact that we can often enough still decide ultimately what we have most reason to do does not imply either that different people would agree on the right resolution, or that even one person can be entirely comfortable with the decision arrived at, giving priority to one over the others, and that the circumstances that make us give priority to one consideration over another in a particular case would tell us immediately what to do in every case of conflict that we may have to consider. A theory of justice has to be alive to the possibility of such plural evaluation. In my book, I quote my friend, again gone now, Bernard Williams, by saying disagreements don't necessarily have to be resolved. They don't have to be in a proper theory of justice, I would argue. They do have to be in a social contract approach. They do have to be in the original position to arrive. They do have to be in the Dworkin's priority of equality of resources. They do have to be in Nozick's priority of liberty, including property rights. They do have to be in Gauthier's resolution, and so on. There's a major contrast there. So this, to accept such plurality does not undermine the reach of reason over unreasoned inclinations. The plurality that you accept is the result of reasoning, not abstention from it. The approach that is presented in the book has the advantage, I think, of not making the alleged best to be the enemy of the agreed good, an issue of huge importance, for example, in the current debates in the reform of American healthcare, or the restructure of global economic institutions, the World Bank, the UN, the IMF, and so on. I was myself involved in a small committee about the IMF reform, and what we recommended isn't a perfect word, but that was something on which we could agree at this time, and on a very wide basis. It also opens up the possibility of allowing the pursuit of global justice in general, and in particular the advancement of human capabilities across the globe, without waiting for the establishment of a global state. The focus has to be on the importance of global public discussion and the reasoned but limited agreement that could still emerge. Let me comment briefly on how restrictive the approach to justice through social contract approach tends to be when we move beyond the boundaries of a state. For example, in the Rawlsian theory of justice as fairness, the application of his principles of justice requires an extensive cluster of institutions that determine the basic structure of a fully just society within the confines of a sovereign state. Not surprisingly, Rawls actually abandons his own principles of justice when it comes to the assessment of how to think about global justice. And it does not go to the fanciful direction of wanting a global state. Some other people have done that, but Rawls didn't, in my judgment, rightly. In a later contribution, The Law of Peoples, which actually the original lecture on which the book is based was given in Sheldonian Theatre many years ago as an amnesty lecture, Rawls there invokes a kind of supplement to his national or within-country pursuit of the demands of justice and fairness, but this supplement comes in a very emaciated form through a kind of negotiation between the representatives of different countries on some very elementary matters of humanity and civility, which can be seen as very limited features of justice indeed. In fact, Rawls does not try to derive any principles of justice that might emanate from these second-stage negotiations. Indeed, none would emerge that can be given that name. And he concentrates, and it couldn't have, because if you're looking for perfectly just institutions, there is no global state to carry this out. And he concentrates instead on certain general principles of humanitarian behavior, or considers a strong dismissal of the relevance of the idea of global justice by one of the most original, most powerful, and I believe most humane philosophers of our time, namely Thomas Nagel, from whose work, like those of Rawls, I've learned so much. In a hugely engaging article in Philosophy and Public Affairs in 2005, Nagel draws exactly on his transcendental understanding of justice, transcendental institutional understanding of justice, to conclude that global justice is not a viable subject for discussion, since the elaborate institutional demands needed for a just world cannot be met at the global level at this time. As Nagel puts it, I quote, "It seems to me very difficult to resist Hobbes's claim that the relation between justice and sovereignty, it was very difficult to resist that claim. And if Hobbes is right, the idea of global justice without a world government is a chimera." Is that the right pronunciation? Chimera rather than chimera? Chimera. Okay. In the global context, Nagel concentrates, therefore, on clarifying other demands, distinguishable from demands of justice, such as, quote unquote, minimal humanitarian morality, unquote, which, as Nagel puts it, governs our relation to all other persons, and also to long-run strategies for radical change in institutional arrangements. And I quote from Nagel again, "I believe that most likely path towards some version of global justice is through the creation of patently unjust and illegitimate global structures of power that are tolerable to the interests of the most powerful current nation states," unquote. You can see what's happening. He is thinking about there's no justice, of course, until you get to the final point. So you're trying to short-circuit this as much as possible. Rather than saying these intermediate stages, how do they compare with each other in terms of justice and injustice? The contrast that is involved here is between seeing institutional reforms in terms of their role in taking us towards transcendental justice, as outlined by Nagel, and assessing them in terms of the improvement of human lives and freedom that such reforms actually bring about right now, particularly through the elimination of what are seen as cases of manifest injustice, which is an integral part of the approach I have tried to present in my book. Indeed, the theory of justice as formulated under the currently dominant transcendental institutionalism of the social contract approach reduces engagement with many of the most relevant issues of justice into simply into empty, though well-meaning, rhetoric. But when people across the world agitate to get more global justice connected with hunger, lack of medicine, lack of education, torture, and hundreds of other things, and I emphasize here the comparative word more in more global justice, they're not clamoring for some kind of quote-unquote minimal humanitarianism, nor are they agitating for a quote-unquote perfectly just world, but merely for the elimination of some outrageously unjust arrangement to enhance global justice, as indeed Adam Smith or Condorcet or Mary Wollstonecraft or Mill or Marx did in their own time, and on which agreements can be generated, they thought, through public discussion, despite continuing divergence of views on other matters. But are these clamors for more global justice really genuine, or are they really based on reasoning rather than some kind of a pure illusion, what Tom Nagel calls a chimera? What kind of reasoning is involved in insisting that we move from closed to open impartiality in the pursuit of greater justice in the world? There are, I think, two principal grounds for requiring that the encounter of public reasoning about justice has to go beyond boundaries of a state. One, the relevance of other people's interests, which may be affected by what we do. Two, the pertinence of other people's perspectives, their understanding, to broaden our own investigation of relevant principles for the sake of avoiding our own parochialism based on the values and presumptions only and exclusively in the local community. The first ground, related to the interdependence of interests, motivated Adam Smith to criticize the injustices that he saw around his 18th century world, varying from barbarity of slavery on one side to the tyranny of early colonialism on the other. Adam Smith did, in fact, make good use of the reach of global reasoning connected with interests in many examples of each of his books. For example, the misdeeds of early British rule in India, including the disastrous famine of 1770, engaged Adam Smith greatly in The Wealth of Nations, where he concluded that the East India Company, I quote, not only oppresses and domineers in the East Indies, but is altogether unfit to govern its territorial possessions. When Adam Smith wrote that, he was not drawing on any oddly devised social contract. It would have been very hard to fit that judgment in the contractarian framework, but on the kind of reach that the impartial spectator allows without confining judgments of justice within the limits of a sovereign state. Similar issues remain very alive today. How America tackles its economy influences not only the lives of Americans, but also in the rest of the world. Similarly, AIDS and other epidemics have moved from country to country and from continent to continent. And also on the other side, the medicines developed and produced in some parts of the world are important for the lives and freedoms of people far away. Also, what can be said about the environmental challenges we face today, for example, about the threat of global warming, has to be based on global reasoning about the sharing of obligations and burdens to enhance our joint response, taking note of the interests of the world community rather than sticking to a strictly contractarian line of analysis of perfect justice confined within the limits of a sovereign state. In addition to the global features of interdependent interests, there is a second ground, that of avoidance of the trap of parochialism, to which Smith points, for accepting the necessity of taking an open approach to examining the demands of impartiality. If the discussion of the demands of justice is confined to a particular locality, a country, or even a larger region than that, there is a possible danger of ignoring or neglecting many challenging counter-arguments that might not have come up in local political debates, but which are eminently worth considering in an impartial perspective. Smith was particularly concerned about avoiding the grip of parochialism in jurisprudence and moral and political reasoning. In a chapter entitled, and it's one of those chapter titles which reveals a lot, I quote, the title is on the influence of custom and fashion upon the sentiment of moral approbation and disapprobation, unquote. In that chapter, in the theory of moral sentiment, Smith gives various examples how discussions confined within a given society can be fatally limited by parochial understanding. One of the techniques that Smith followed, which I think people don't often comment, when he is criticizing a practice, he never fixes an example which his natural audience would tend to look down upon. He discusses Chinese foot binding, but it doesn't come in when it comes to castigation on that. He picks what a properly trained Briton would, namely ancient Greece and Athens. Because if you can make a point with that, then I think A40 or you could make points about other places. So I quote from Smith. It's a long quote I'm afraid, longish. The murder of newborn infants was a practice allowed of in almost all the states of Greece. Even among the polite and civilized Athenians, uninterrupted custom had by this time so thoroughly authorized the practice that not only the loose maxims of the world tolerated this barbarous prerogative, but even the doctrine of philosophers, which ought to have been more just and accurate, was led away by the established custom. And upon this, as upon many other occasions, instead of censoring, supported the horrible abuse by far-fetched considerations of public, quote-unquote, public utility. Aristotle talks of it as of what the magistrate ought upon many occasions to encourage. The human Plato is of the same opinion, and with all that love of mankind which seems to animate all Plato's writings, nowhere marks this practice with disapprobation, unquote. While Smith's example of infanticide remains sadly contemporary today, though only in very few societies, some of his other concerns have relevance to many other contemporary societies as well. This applies, for example, to Smith's generalist insistence, and that's the general approach I quote here, the eyes of the rest of mankind must be invoked to understand whether a punishment appears equitable, unquote. Scrutiny from a distance may be useful for practices as different as the stoning of adulterous women in Taliban's Afghanistan, selective abortion of fetal fetuses in China, Korea, and parts of India, and plentiful use of capital punishment in China, or for that matter, the United States. It's perhaps striking that US executes more people each year today than any other country in the world, with only 3 exceptions, namely China, Iran, and Saudi Arabia. The relevance of distant perspectives has a clear bearing on some current debates in the United States. For example, that in the US Supreme Court not long ago on the appropriateness of death sentence for crimes committed to a person's juvenile years. The demands of justice being seen to be done, even in a country like the United States, cannot entirely neglect the understanding that may be generated by asking questions about how the problem is assessed and seen in other countries of the world, from Europe and Brazil to India and Japan. The majority judgment of the court, as it happens, ruled against the use of the death sentence for a crime that was committed in juvenile years, even though the execution occurs after the person reaches adulthood. So you wait until he or she becomes adult, and then grab him and kill him. In denying the appropriateness of capital punishment in this case, the majority, D then, of the Supreme Court did not simply defer to, I quote, defer to like-minded foreigners, as Justice Scalia said, who expressed a minority view against that. He would have preferred execution in this case. The composition of the US Supreme Court has in fact changed since then. In an explicit statement at his confirmation hearing, the current Chief Justice, John Roberts, Jr., has expressed his agreement with the minority approach of the court, of Justice Scalia and others, which would have allowed execution for a murder committed by a minor person as he or she reaches adulthood. I quote from Roberts, "If we are relying on a decision from a German judge about what our Constitution means, no president accountable to the people appointed that judge, and yet he's playing a role in shaping the law that binds the people in this country." This is the argument for closed impartiality. To this Justice Ginsburg, who voted with the majority of the Supreme Court at the time of the judgment, has responded, I quote, "Why shouldn't we look at the wisdom of a judge from abroad with at least as much ease as we would read a law review article by a professor?" There is a legal tension here, which I might come back here, because next year I'm giving the Hart lecture here in Oxford. Namely this, that Scalia, who takes what is called the originalist position, namely who interpret the Constitution as it was originally intended. The interesting point is that the Constitution, famous in America, of course, was steeped in European thought of that period. So there's very difficult way of understanding what was in their mind and how these ideas have been played out since then in Europe after that time. So there's a real tension in the originalist position and its closed impartiality. General wisdom is certainly one issue, and Ginsburg is right to point to that, as were the framers of the US Constitution in the 18th century, to think that better understanding can come from abroad as well as from home. But there is a more specific point made by Adam Smith, that distant judgments are particularly important to consider and scrutinize to avoid incarceration in local or national parochialism. It is for that reason that Smith argued for taking note of what is seen by, I quote, "the eyes of the rest of mankind," unquote. Scrutinies from a distance can be very useful in order to arrive at grounded but not parochial judgments, taking note of questions that considerations of non-local perspectives can help to generate, as Smith discussed and illustrated in great detail. Indeed, the apparent cogency of parochial values often turns on lack of knowledge, precisely, of what has proved feasible in the experience of other countries. The inertial gut defense of infanticide in ancient Greece, on which Smith spoke, was clearly influenced by the lack of knowledge of other societies in which infanticide is ruled out, and yet which do not crumble into chaos and crisis as a result of not permitting such killing. Despite the undoubted importance of local knowledge, which is celebrated much now, every time one goes through Heathrow, I see that one of the banks is always advertising the importance of local knowledge everywhere. But despite all that, global knowledge too has some value and can contribute to debates on parochial values and practices. So I conclude on this note about the global justice issues, to listen to distant voices, which is part of Adam Smith's exercise of invoking the impartial spectator, does not require us to be respectful of every argument that may come from abroad. And this is worth emphasizing to avoid a common misinterpretation of the Smithian device. Willingness to consider an argument proposed elsewhere, and that's what the impartial spectator is doing, asking questions, is very far from a predisposition to accept all such proposals. We may reject a great many of the proposed arguments, sometimes even all of them, and yet there would remain a particular case of reasoning from abroad that could make us reconsider our own understandings and views, linked with the experience and conventions entrenched in a country or a culture in a specific case. Arguments that may first appear to be outlandish, especially when they do actually come initially from other lands, may help to enrich our thinking if we try to engage with the reasoning behind these locally atypical contentions. The interdependence of reasoning in the world is part of the ground on which Martin Luther King Jr. said in a letter from Birmingham jail in April 1963, I quote, "Injustice anywhere is a threat to justice everywhere," unquote. Active public agitation, news commentary, open discussion, debates, protests are among the ways in which global democracy can be pursued, even without waiting for the global state. The challenge is the strengthening of this already functioning participatory process. It's not a negligible cause, nor, I claim, is it beyond our reach. Thank you.